The statement which was provided by the NIA, we will find there is C difference. C difference in the sense of only on those accused persons, those are falsely implicated in UAPA provisions. In respect of normal writing sections or IP section, there is no difference, because we can conclude in such a way that when entire investigation got over, that time NIA got some certain instructions to invoke a UAPA provisions to match with the ingredient of the Terror Act, or to target a particular people. I am not talking about the particular sections or particular community, to target particular individuals. The NIA has fabricated the statement connecting the allegations against those accused persons.
So most of the accused who have been arrested in DJLE, as well as in Praveen case belong to one association called Popular Front of India. Do you think that this was fabricated to target Popular Front of India?
Basically, I tell you, see this. You know that what is going on in the present scenario. Whoever used to stand against the government, government used to talk. See that a step central government has taken to target PFI, and the matter is before the Supreme Court. So I don't want to say much about it. See, in respect of these two cases, DJLE, KJLE case, the allegations are against the SDPI people, not against the PFI people. In the case of Praveen Nettor case, it was a local incident, and subsequently it was been transferred into on the PFI people. Okay. So I am not going to defend any organization at this point of time. I am saying that there is a certain things happen in society where some individuals been targeted. To target those individuals, they required evidences. Okay. So to target those people, they have manipulated certain evidences to target the individuals. Like in the Praveen Nettor case, as I said, that state police, whatever investigation state police has done, during that investigation period, we never heard, even no media friend also may be aware that, we never heard that any eyewitness was there. But when found the charge sheet, suddenly there was eyewitnesses. Those are giving a testimony against a particular individual. They have seen the incident. But how it has happened? When we received the document from the state police, and NIA has not given a document in the first instance, we filed the application, they objected. After a great effort, they had given a document. When we compared the document, we found that all the eyewitnesses' statement of number, because we did not get the original statement, the number of pages was mentioned there. Say example, one witness statement, number of pages are mentioned, 4 pages. So if they received a 4-page statement from the state police, certainly they have to give the same pages, number of pages. If suppose they would have corrected a further statement of the same witness, that time we would not have any ground. They have presented the same statement, stating that it is the same statement on the same date with the signature of the same officer. So there the doubt is arise. We don't know what level they had been fabricated, because the original statement is not with us. But from this prime facie document, we can say that's a fabricated statement. For that reason, see, there is a law is there. When you present a original document to the court, a fabricated document, so the court has to conduct an inquiry under section 340. So we already filed a complaint by narrating all the facts, and I hope the court will consider it and will pass an order.
Sir, as per your statement in the press conference, what you said is that the cases or the charges have been framed and manipulated, fabricated against the accused of the DJ Halli and Praveen Nettor case. So, are you going to challenge this UAPA?
See, basically, you know that how this is a court system. If we challenge it also, it will take years together to come out. See, I just tell you one small incident. I take example of DJLE, KJLE incident. I am not supporting this incident, and this is condemnable incident, and this our civil society, such incident should not be happen. But see, this stationer attack, UAPA was involved. You may be aware that there is an incident happened in the Lal Killa during Kisan protest. There are so many police were attacked. UAPA was involved? No. Hardik Patel case was there in Gujarat. There are more than 17 people who died. 9 police also died. In that all incident, not even a single UAPA was there. You may be aware the incident of Ram Rahim arrest. When Ram Rahim was convicted, there is a large scale violence was happened. 47 police personnel were murdered. How many? 47 police personnel. But no UAPA was there. So wherever a member of minority community involved, either a DJLE, KJLE or in a Hubli case, they immediately invoke UAPA. In Manipur, 60,000 FIRs. How many? 60,000 FIR. Not even one single UAPA. So these are the conduct of the agencies, which gives a scope for a questioning.
So do you think all this was manipulated to ensure that UAP Act is been imposed and it becomes more difficult?
See, basically what, two people to come out.
Two
people to come out to from the bail. See, that is the only intention.
Can you make a full statement of that?
See, there is a very specific statement in respect of Praveen Netral, I tell you. See, there is 8 incident was happened. 8 incident, murder incident, communal murder. Minority murder, majority community murder, minor. But all it is a murder incident, purely murder incident. But only selectively 2 incident, UAP was invoked. All other 6 incident, UAP was not invoked. I had given you details of all the FIRs with the statement, and I had given the bail orders number also. In all the 6 cases, bail was granted. In the 2 cases where the Muslims were accused, bail were not granted. That is only because of UAPA was invoked. But it is a simple murder case, and in Supreme Court in senior 9R case in 2017 itself clearly stated that in the cases of communal murder, UAPA cannot be invoked, terror cannot be considered a terrorist activity.
So DJL and KGL case under UAP, how many people are inside?
See, there they had fabricated, they had implicated 49 people at first instance, and thank God with the help of the order of the Honorable High Court, we got the default bail of in respect of 12 people. But those were arrested in month of December 2020. There is more than 37 people, or exactly 37 people are there. They are still inside the jail after 3 years. And we hope that with the help of these evidences, because we got this evidence little later, and we are convincing the court to appreciate this contradiction and grant a bail. This is the case of writing. Nobody is disputing it. But it should not be, the UAP should not be known, it should not be considered as a terrorist act. And particularly, forget that terrorist act. Those people are inside the jail. They actually help the police. It is there in the video. All 5 hours video is there. Anybody wants to see, I can provide that video. In all the 5 hours video, you will not see one instance where any of these people, those are inside the jail, were doing any illegal act. On the other hand, they were helping police. They were helping police. They were in the side of police. In spite of that, some section in the government, they want to target individuals, so they have targeted. And to facilitate the target, they fabricated some statements, which I already stated. I have just pointed out why I pointed out Innova case. Only one Innova car was there, which was banned. State police has not only investigated, they also investigated by perusing the CCTV footage. Based on the statement was recorded. Based on that, they held that this 4 accused person has committed this act. In spite of that, in December 2020, when other accused are arrested, then NIA has fabricated the statement of police personnel. See, assume that Inspector Ajay, if he may be aware about a burning of a Innova car, is this burned by a so-and-so person. So certainly he would have given this statement to his own police station, which is who is investigating the same case. So that is only give a scope of all these allegations. Otherwise, we know that all the intelligence, all the investigating agency, they do their work. But you know that central agencies, how they will get manipulated. And now it is the open secret. Even Supreme Court has said several times, they stated that these central agencies are the pirate of the central government. So there is nothing new I am going to say. And this is fact which we are saying it.
Thank you, sir. So what if that is the clinching evidence documents you have you presented before court, and what is the court is saying to that?
See, I have presented this clinching evidences. Court is saying that so far this evidence has to be tested at the time of trial or in the time of charge. So far charge has not been framed. With the help of these evidences, we have filed a bail application. We are hopeful that very soon they will get justice. They will come out. I have a confidence justice can be delayed, but it will not be denied. I am sure about it.
Thank you, sir. Thank you.